fixed for not tomorrow, but the following week.
Okay. And what the people are concerned about, my understanding is that the defense would like to bring up the fact that Mr. Budgel has cancer and that he made the trip from Hawaii, notwithstanding the fact that he has cancer. I think that is not relevant as to the impact that either the victims or Mr. Martin had on Mr. Budgel's life experience. And I think, if anything, it's 352. It's to create sympathy for Mr. Budgel and increase his believability or credibility for the fact that he has cancer and made the flight all the way from Hawaii, notwithstanding COVID times and probably against his physician's request or demands.
All right, Mr.
Exactly. He's coming here against doctor's orders. He has cancer. His most recent treatment, I believe, was in July, and I think he's coming here because, and he's risking his own health because this is so important to him, and I think, and Mr. Martin is so important to him, and so I think it's important for the jury to understand what he is risking to be here for those reasons. I think it just adds to his credibility as a witness.
Well, as you all know, the litigation of the testimony talk about the impact, potential impact on their life. We don't know how suffering with their own testifying about it. And why you want to offer active relevant to their credibility in the sense of I don't think they're going to be attacked by attack their closeness. That they know and process. That there is a challenge. Credibility. Some way. And he would effort on the A or not. The prosecution side is relevant. How they're active. Yeah. Positive character. I'll deny without prejudice. All right, next.
Yes, in the guilt phase, with regard to Michael Anderson's cross-examination, the defense had brought up the civil lawsuit that they were part of. I don't see how that's necessarily relevant in the guilt phase, at least with these witnesses. I'm sorry, in the penalty phase, at least with these witnesses. My understanding is that they may intend to call Dr. Rosario and a nurse, Gabriela Maciel, that both worked for ETS. I could understand that might have more of an impact or more of a relevancy, so I'm not necessarily objecting to that. But with regard to the victims, I don't believe that at this point the lawsuit, the fact that there's a lawsuit or not a lawsuit, I don't see how that would impact the loss or their impact statement as far as it goes.
It goes to bias. The lawsuit, you need damages. What are the damages in a wrongful death lawsuit? how this person's death affected me. It's exactly the same type of testimony they're eliciting from the witness.
Yeah, I think I would agree. Let's have it Austin. After there may be trial, sorry. Yes, like that was. But there may some witnesses' testimony possibly oppose his testimony. Detrimental. Next.
Yes, there is a video. It's remarked as People's 273 that we'd like to play. Basically, it's a video that Jeremy Swanson made regarding the loss of his father. And I understand it was made a year ago, so at that time it would have been 4 years of loss for Mr. Swanson. I don't believe the defense is objecting to the video, but there is narration that goes along with the video, and the people are intending to play the video with the audio, with the narration. The narration is by Jeremy Swanson, who will be here to testify today. So he's going to be available, and he's going to be the one laying the foundation for it.
So is it a simple matter of him saying, this is me and Swanson at a football game while he's talking on the video, or is it something else?
Yes, it's a video. It's basically a photo collage. So there's really not a whole lot of quote video. It's more of a collage. There are snippets of video within the collage, but it's him narrating just about the effect of loss that he suffered for the last 4 years. And I'll cite for the court People v. Mills, MILLS. It's a 2010 case, 48 Cal 4th, 158, page 212. In that case, a videotape was properly admitted where video included the victim's boyfriend expressing his guilt flowing from the fact that he quarreled with the victim, causing her to leave their car in an attempt to walk home, events which led to her death. That witness also testified at the penalty phase and was able to lay the foundation to the video with audio.
Correct.
I believe so. If there is music, it's in the background, and I can check very quickly. I can't recall.
Here's the problem. It's hearsay. He's testifying. And also in the video, there's audio of a child talking about how she misses, I think maybe grandpa, I don't even know if it's a male or female child, how much they miss grandpa. He's narrating, he's not narrating photos saying this is us a football game, this is us riding motorcycles. He's talking about how much he misses his father and what this all means to him, which is exactly what he'll be testifying to.
Well, I have a concern also on the video, not the witness. There's another person, in other words. That's
Like I said, it's a photo collage, so all the photos are of Barry Swanson, and yes, some of it is with other people in photos, but it's not the witness testifying about the photos. The witness, I should say, narrating about the photos. The witness is narrating about the loss of his father, and it just so happens that there's a photo collage going on in the background.
Right, I guess. If the only voice that's on the video is the witness who's testifying, I don't know what the difference is. Photos going up and talking about it.
Right.
But if there are other voices that are on the video of people who are not testifying, that would be a problem.
There are two parts. The entire video is approximately 2.5 minutes long. There's one line by an unknown child that says, "Hi, Poppy. I just want you to know I miss you so much and I wish you were here. Love you." And another child, I don't know, I believe it's a different child. "Hi, Poppy. This is Reed. I just want you to know how much I miss you and love you."
So those would have to be edited because those aren't witness cross-examination. Certainly the witness can have the photographs without sound and narration, or the witness's voice can be on there, whatever they're saying, and then the witness is subject to cross-examination if they're the ones that are on the stand. The problem is there's other voices of other persons talking here under oath. Cross-examination. So either the video needs to be played without the narration, or if it's played, it needs to be edited. The other person.
Or you bring the children in.
Or bring the children in, of course. That's fine, because then I don't know. Cross. However you wish.
All right, just one second. Okay. All right. I think we'll bring the children in then, unless the defense wants to withdraw their objection.
Did we just have an opportunity to think about that? I don't
Sure,
know.
sure, of course. When is that witness due in your client?
He's third.
Third up this morning. It's Jeremy Swanson, who's the son of Barry Swanson,
Right.
and those two children are Jeremy's children.
Are they here?
They're close by. Jeremy just lives up the street, 10 minutes away. So we can bring him here, and we can put on these 5-year-olds to say that they love their grandpa.
Well, that's a tactical decision the defense will make. I certainly would not preclude them from testifying. But I don't think it's fair to just...
I understand.
Understanding that whether these people testify or not, I still believe it's hearsay. I understand you disagree with that and you've overruled that objection. Whether they testify or not, I still think it's hearsay. Abiding by the court's ruling, obviously for tactical reasons, we'd rather have the video than the children here.
All right. Over to you.
Yes.
All right, then for tactical reasons, court will allow the video to be played active.
Very good. I know I said 3. There's a fourth minor issue. So, we have one witness, Diane Johnson, who was supposed to testify today. She is in the hospital, and so she will not be able to make it today. I don't believe it's going to be something that's going to be long-lasting. We expect to finish early today anyway. My request is to potentially put her on tomorrow without resting today, or maybe take her out of order and put her on next week, if that's all right with the court and defense.
Well, that's fine. I don't imagine the defense would have an objection either tomorrow.
We don't. No, I'll talk to Mr. Beecham. We have what could be tight scheduling issues tomorrow because we're going to be bringing in professionals. We promise these professionals will get them. They don't have to wait around. So
that's fine.
We'll Mr. Beecham about scheduling. Obviously, we don't have a problem with taking around.
All right.
That's
so
fine.
either tomorrow or Monday.
Right.
Is there an actual list of witnesses, or are they?
They're not.
They're not. I can read them, Your Honor.
Both give me a list. I can read it.
Yeah. Well, there is another issue that we discussed on Thursday that we'd agreed on, and Wednesday rather, and that was, the court will recall, I was worried about what instances of 190.3 aggravation acts that Mr. Martin committed that the people would try to elicit from family members. And we've agreed that they can elicit 4 specific instances. One is an instance with scissors that Brandon brandished in front of his mother and his brother. Second is an instance where Brandon laid hands on his mother and left bruises that the police officers were able to see. Third is an incident that his brother Sean related to the police where Brandon had head-butted him. And fourth, there was an assault on Mr. Martin, on Brandon's father, while he was sitting in a chair that resulted in Mr. and Mrs. Martin getting a restraining order against Brandon.
All right, so the people's factor B character be limited.
And the people agreed that because Sean, when he's interviewed, talked about numerous incidents, that those are the four that were enumerated by him. The people have agreed they're not going to do a general fishing expedition to Sean. Hey, is there anything else out there? People agreed they're not going to do that.
I'm not going to do a fishing expedition. The citizens say the hands on the mom, the headbutt. The headbutt was on 3/15 of 15. I think there may be another incident that day regarding Mr. Martin, which is a separate incident from Michael Martin being assaulted by Brandon, which happened in September of 2014, which is when they got the restraining order. So there's 5 incidences. So there's the scissors, hands on mum, 3/15 or 15, headbutt to Sean, and then an assault on Mr. Michael Martin that day. And then Mr. Michael Martin was assaulted by Brandon Martin on September of 2014.
So 2 assaults on Mr. Martin Sr.
Yeah.
Yes.
All right, and I assume for tactical reasons, Mr. Walburn has come to that agreement based on the fact that there could be other issues out there, like more in volume or nature, to agree to just limit without objecting to for these pieces of evidence.
That's correct, and there's no question that they fall within incidences of aggravation, that they are incidences of violence or threats of violence. Point 3.
Yes.
Right. Anybody else?
Not from the defense.
Does the defense have a witness list?
Mr. Wellborn is writing it as we speak.
And I'm writing on it.
All right. So while you're doing that, I gave both sides the pre-instructions to the jurors. Court's intending on reading California 760, 761, 763, and I'm going to read all of the factors, and 766. They'll be read again post-trial unless there's some objection.
No, there's no objection. In addition, I did not submit any jury instructions because I reviewed the people's submission of jury instructions, and I would have just submitted a duplicate list. So I concur with what the people submitted with respect to jury instructions.
Right, and the additional instructions are based on the aggravating factors like criminal conduct on charge.
Yes.
So we'll deal with that when we get instructions. Are the people all right with the reading indicated?
Yes.
All right. Now, next question that I have for you before we bring our jurors in is I know there was some discussion about witnesses not wanting their names to go out screaming. We have one witness in defense of the court has agreed to allow the video streaming and audio streaming to come on after she's sworn in and thereafter referred to by her first name. Are there any witnesses that people have with the same
No.
I need to know in advance because Madam Clerk is the one that's controlling the live stream. And so when the witness comes in, if they're going to swear in, we have to know when the audio. All right. Else?
No.
No,
Who's
thank
going to
you.
be giving the opening to people? First, Mr. Alderman, you're going to be doing it.
Yes, sir.
All right, we have the camera set up, so we're good to go. All right, if there's nothing else, once they have the list of the names